Good morning, students. In this video, we are going to study about the formation of partnership, or you can say how the partnership is formed and the partnership deed. See, you know that any partnership can start with the mutual understanding or with the contract between two or more person. There is no proper mode of formation of partnership. Is it clear? So there is no you can say registration for the partnership firm is also not mandatory. Okay, it is just on the basis of the contractual relationship between two or more person, and this relationship is based upon mutual trust and good faith. Now, they start up a partnership. You know that why they start up a partnership: to conduct a lawful business and as well as to share the profit and losses of the firm. And in order to avoid disputes, the partnership agreement should be in writing, but it is not mandatory that it should be there in the written aspect only. So, according to the Partnership Act 1932, is it clear? Or you can say, if there is no partnership agreement, then the rights and the duties of the partners are established by Partnership Act 1932. Now, what do you mean by partnership deed? A partnership deed is a document. What it is? It is a document. Underline this keyword, document, containing the terms and conditions. Underline the word terms and conditions of a partnership. It is an agreement in writing. Underline the word in writing. Signed by all the partners. Underline by all the partners. Duly stamped. Underline duly stamped and registered. So, what is a partnership deed? A partnership deed is basically a document, a written document, where all the terms and conditions of the partners are mentioned, as well as it is signed by all the partners and it is registered and duly stamped. In that, you can get all the rights and duties, or you can say all the obligations of the partners, as well as the relation among them in conduct of the business. Okay. So, what are the clauses of partnership deed? No need to learn all the clauses, learn any 5 to 6 clauses. Like in a partnership deed, name of the firm is to be mentioned. Nature of the firm's business means what type of business you are going to start up. Principal place of the business, where are you going to start up your business. Duration of partnership, for you can say for which how much time you are going to continue, for name and address of the partners, amount of capital contributed by each partners, drawings by each partners, profit sharing ratios of each partners, rate of interest if any, and rate of capital or drawings also. So you can learn any 5 to 6 clauses among these. Next, come to the registration of partnership. Registration of a partnership firm is not at all compulsory. But according to the Partnership Act 1932, if the partner wants to get their firm registered, they can register it with the registrar of the firm of the state in which the main office is situated. For example, the main office of the partnership firm is in Jamshedpur, then they have to get it registered by the registrar of the firms of Jamshedpur. What are the consequences of non-registration? If a partnership firm is not registered, it cannot enforce its claim against any third party in the court of law. Means it cannot claim anything against the third party. Second is, it cannot claim adjustment for any sum exceeding rupees 100. 100 रुपए से ज़्यादा का क्लेम के लिए वो लोग नहीं जा सकते हैं. Suppose an unregistered firm owns 1200 to rupees A and A owns 1000 to the firm. The firm cannot enforce adjustment of 1000 in the court of law. Third is, it cannot file any complaint against any of its partner if there is no registration. Next is, partnership of an unregistered firm cannot file or sue to enforce a right against the firm. They cannot file any complaint against the firm. Fifth is, partners of an unregistered firm cannot sue to file against other partners, means they cannot complain regarding any other partner. Non-registration of a firm, however, does not affect the following rights. The first one is the right of the partners to sue for the dissolution of the firm for the accounts of a dissolved firm or to enforce any right to power to realize the property of a dissolved firm. If the firm has been dissolved, if the firm has been winded up, then the partners can claim the power of an official assignee or receiver to realize the property of an insolvent partner. Like an official registrar can be appointed to get the properties of the partners. Third is the right of the partners or its partners having no place of business in India. If they are not having any business in India, then they cannot claim. Next is the right of the third party to sue the unregistered firm of its partner. If the firm is unregistered, then the third party cannot sue or complain against the firm. The right to sue a third party for infringement of a patent right. If they are copying anybody's patent right, then they also cannot file any complaint against them. So, in this video, we are going to study about this much only. In the next video, we will study about different types of partnership and the types of partners. Thank you. Bye.